Hi and welcome. In today's episode, we're talking about neutrality illusion within the judicial system. So, judicial impartiality, structural imbalance, and the constitutional limit of procedural fairness. In this podcast, we'll dive deep into a postgraduate level policy analysis examining judicial impartiality, Article 6 rights, equality of arms, procedural fairness, structural imbalance, vulnerable litigants, adversarial systems, and the constitutional limits of neutrality within modern family proceedings. The neutrality illusion, judicial impartiality, Article 6, and the procedural fairness. This is a legally grounded analysis examining judicial impartiality, equality of arms, Article 6 rights, procedural fairness, structural imbalance, and safeguarding failures within family court systems. So, let's dive in and talk about it, shall we? This topic examines one of the most constitutionally sensitive questions within modern court systems: whether procedural neutrality alone is capable of producing substantive fairness, because modern courts frequently define justice through neutrality, impartiality, procedural consistency, and equal application of the rules themselves. These principles are constitutionally essential. Without impartiality, justice collapses. Without judicial independence, the rule of law deteriorates. Without neutrality, courts lose legitimacy entirely. Yet, there is another constitutional reality that requires equal attention. Neutrality alone does not automatically eliminate structural imbalance, evidential asymmetry, participation impairment, economic disparity, or trauma-related disadvantage through process. And where one party enters proceedings with greater resources, greater procedural endurance, greater emotional regulation, and greater institutional familiarity, while the opposing party enters traumatized, exhausted, financially depleted, psychologically dysregulated, or procedurally overwhelmed, neutral procedure may produce formally equal process, while operationally unequal participation. This is the neutrality illusion. The belief that equal procedural treatment automatically creates substantive fairness through proceedings, regardless of structural conditions, that remains to be seen. But let's examine that. The judicial impartiality, Article 6 of the Human Rights Act, and equality of arms, neutral justice, vulnerable litigants, and structural imbalance, adversarial systems, and the constitutional limits of procedure neutrality itself. So, what is judicial impartiality and the rule of law say? Judicial impartiality remains one of the foundational pillars of constitutional democracy. Courts must remain independent, objective, and procedurally fair. The legitimacy of the legal system depends upon public confidence that decisions are reached through law rather than bias. The principle is reflected throughout common law, traditions, Article 6 jurisprudence, procedural fairness doctrine, and the wider constitutional architecture of democratic societies. The issue examined in this episode is not whether judicial impartiality matters. It does. The issue is whether impartiality alone is sufficient to neutralize structural imbalance within adversarial systems. There's a distinction because neutrality operates within environments already shaped by financial disparity, evidential inequality, procedural complexity, institutional fragmentation, and trauma-related participation impairment. So Article 6 and the equality of arms. The Human Rights Act 1998 incorporated Article 6 ECHR, which requires fair hearing rights, procedural fairness, and equality of arms through the courts. So equality of arms does not require identical outcomes, nor does it require preferential treatment. It requires realistic procedural opportunity to participate without substantial disadvantage. This distinction is critical and critically important because formal neutrality does not necessarily eliminate practical inequality. If one party possesses extensive legal representation, financial resilience, procedural literacy, and emotional stability, while the opposing party experiences trauma, cognitive overload, participation impairment, financial exhaustion, or procedural collapse, the existence of identical procedural rules may not produce substantive equal participation within the hearing. This creates constitutional asymmetry beneath procedural neutrality. The adversarial model and structural imbalance within the family court proceedings itself largely operate through adversarial frameworks. The adversarial system assumes parties can present evidence, challenge allegations, organize disclosures, and advocate effectively for themselves or through representation. However, this assumption becomes constitutionally fragile where participation capacity itself becomes unequal. Trauma affects memory, cognition, emotional regulation, concentration, communication, executive functioning, and procedural endurance. Economic disparity does affect representation, especially where expert access, litigation, sustainability, and evidential resources are depleted. The result is structurally unequal. Participation operating beneath formal neutral procedure is not invoked. The myth of procedural equality within modern family courts is one of the greatest constitutional misconceptions within modern litigation culture. Procedural equality equals substantive fairness, but equal procedure applied to unequal conditions may preserve imbalance rather than eliminate it. This is particularly relevant within domestic abuse proceedings, financial remedy litigation, safeguarding disputes, and cases involving vulnerable litigants. Because where coercive control, economic abuse, psychological shutdown, or procedural exhaustion already exists, neutral procedural treatment may unintentionally reproduce existing imbalance rather than correct it. So, the Equal Treatment Bench Book. The Equal Treatment Bench Book recognizes vulnerability explicitly. The Bench Book acknowledges that trauma, abuse, mental health conditions, and participation impairment may affect communication, chronological recall, emotional presentation, and evidential performance within a court hearing settings in those proceedings. This is constitutionally significant because adversarial systems often unconsciously reward confidence, fluency, composure, consistency, and emotional control. Yet trauma frequently disrupts precisely those functions. This creates the performance distortion problems where systems risk evaluating presentation rather than the contextual reality of what's actually happening within the court proceedings themselves. So PG3AA and the participation direction, practice direction 3AA requires courts to consider vulnerability, participation impairment, and participation directions. This represents important procedural recognition. However, the existence of participation directions alone do not necessarily resolve structural participation inequality, because participation impairment is not merely logistically, it is frequently neurological, psychological, financial, and cumulative. The constitutional issue, therefore, extends beyond accommodation. It concerns whether systems remain operationally safe under trauma realities. That is the distinction, and that is the real issue. So, neutral justice and procedural principles, or the reality of them, is the principles of neutral justice requires fairness, opportunity to respond, absence of bias, and meaningful hearing rights under Article 6. However, neutral justice becomes constitutionally strained where one party possesses substantial, greater procedural endurance, financial resilience, emotional regulation, and institutional familiarity, because procedural opportunity alone may not equal practical ability to engage safely and effectively. This is particularly important where trauma, coercive control, or economic depletion already impair participation before proceedings even begin. The culture of procedure or procedural performance in the modern family courts through litigation culture remains heavily dependent upon procedural performance. Litigations are often unconsciously assessed through composure, chronology, verbal fluency, confidence, and procedural organization. And yet trauma rarely presents itself neatly. Trauma may produce fragmented recall, emotional dysregulation, shutdown, confusion, delay responses, and cognitive overload. The nervous system is at work throughout. This creates the neutrality illusion, where systems remain formally neutral while operationally privileging individuals best able to perform procedural participation. Safchain argues that safeguarding requires participation integrity, contextual safeguarding, operational continuity, trauma-informed procedure, and institutional recognition of structural imbalance. The objective is not abandoning neutrality. The objective is recognizing neutrality alone may be insufficient where structural asymmetry already exists. This distinction matters profoundly because constitutional fairness requires more than identical procedural treatment in family courts. It requires systems capable of preserving meaningful participation under equal real-world conditions. The constitutional law or the constitutional question right now is this or can Procedural neutrality alone produces substantive fairness where structural imbalance already exists before proceedings even begin. Because where trauma, economic disparity, procedural complexity, litigation exhaustion, and evidential asymmetry intersects, formal neutrality may coexist with operational inequality, and where operational inequality persists, justice itself is at risk or risks becoming procedural legitimate where it's substantially fragile. So, identical impartiality remains essential during proceedings. Neutrality remains essential. Procedural fairness remains essential. But neutrality alone cannot automatically eliminate structural imbalance, trauma-related participation, impairment, economic asymmetry, or procedural exhaustion. The future constitutional challenge is therefore not whether courts remain impartial. The challenge is whether systems remain operationally capable of delivering meaningful fairness under equal real-world conditions. Because where systems rely exclusively upon procedural neutrality without recognizing cumulative variability, participation, inequality, and the structural asymmetry, they risk producing harm, formal fairness, procedure, while operationally unequal justice itself. This is the neutrality illusion. This was Silent Screams, or this is Silent Screams, Loud Strength, Unmasking Justice. You have just been listening to Unmasking Justice. This work is not theoretical. This is postgraduate level safeguarding and legal policy curriculum built from lived experience, constitutional analysis, statutory frameworks, and operational realities currently faced in our modern family courts. It is the difference between knowing what the process says and understanding how the harm happens. Safe chain exists because safeguarding cannot remain symbolic. Safeguarding must become operational, measurable, continuous, trauma-informed, legally coherent, and capable of protecting people across the system that affects their lives. To bring safe chain training, licensing, certification, or the seal of integrity into your organization, visit Safe Chain, the Intelligence Hub, or contact us directly through the website Get in Touch tab. Stop treating safeguarding as an afterthought. Build systems that recognize harm before collapse becomes inevitable. I'm Samantha, your host. Until next time, this was Unmasking Justice. Silent Screams, Loud Strength. Listen to the podcast wherever you hear your podcast from. This is the Sovereign Verdict. Stay safe, demand integrity,